within the common law era. So until the basic law dignity and Bank HaMizrahi case, here is the statute, here is our common law, here are the rights. And what happened now is, here are the rights, they are part of the basic law, so they are the part of the Constitution, and here is the statute that limits those rights. And this statute is unconstitutional unless the limitation of the right fits what this basic law says how to limit rights, namely proportionality. And so we developed the whole idea of proportionality, but proportionality is mentioned already in the text itself. So you asked about the culture of justification. The culture of justification comes in the basic law itself. The basic law says that it's not a culture of power, it is a culture of justification. A statute that affects human rights will be constitutional only if this limitation of human rights will fulfill the requirements which the basic law says the statute has to fulfill, namely, and it says, so it uses the expression proportionality. So this is the main thing that basic law, human dignity and liberties provided. The basic law says that as it was construed, that the basic law is above regular statutes. This is the way the court construed it. It's above regular statutes. And human rights cannot be affected by statute unless the statute is constitutional, namely is proportional. That's a major change. And there is judicial review. And this basic law is a constitutional text. See, you have a constitution, it's written constitution. We don't have such a text. We have 11 basic laws. But we said that's the constitution. So this basic law per se, forget about the court, I think is the revolution. And this is what I wrote in my judgment. The revolution was created not by judges, but by the parliament, acting as the Constituent Assembly. This was my theory, based on Claude. And I cited Claude. It's not the only theory. The other judge, who wrote also a major opinion in this case, Shamgar, he said, no. He was very much against the idea of a Constituent Assembly, a continued Constituent Assembly, etc. He said, no, Parliament is sovereign, but from sovereignty of Parliament, which means Parliament can do everything, if Parliament can do everything, Parliament can also limit its own power. So this was the theory of the other judge. And there is still no decision which theory is the right decision, is the right theory about it. Because there is also a third theory that everything is wrong. And that we are basically back into the pre-revolutionary era. So what Bank HaMizrahi has done, I don't view Bank HaMizrahi as the revolutionaries. The revolution was done by Parliament. Parliament suddenly comes and says, this basic law that I enact today is of a constitutional power. Doesn't use the word constitution, of course, is of constitutional power. And the question, of course, is, can Parliament do it? Because until then, the court says it has not expressed its view if Parliament can or cannot do it, but said Parliament has not done it. And the court basically left it as is, assuming that Parliament hasn't done it, and therefore we don't have a written constitution, a formal constitution. And here comes Parliament and says, one moment, we are doing it. And I researched you asked me if I researched, what happened in Parliament in those days. I researched it very heavily. The picture of what happened in Parliament in 1992 is very unclear. Probably some of the members of Parliament thought that yes, there is a constitutional revolution that we Parliament are doing. Especially the opposition to this revolution was very noisy in Parliament, saying, look what happened here. By this basic law, we are making this constitution. There were others who said, no, nothing happens. And there were others who just said, we don't know what happened. So the picture from Parliament is very, very unclear. But at least it's quite clear that the members of the committee that drafted this basic law, at least the main figures, assume that what they are doing now is creating a super statutory norm that can knock out statutes, regular statutes, which are in violation of what is said. This was their assumption. And they also assumed that there will be judicial review. And in this respect, when the Bank HaMizrahi came, we gave force to this attitude that Parliament itself expressed in 1992. Parliament by itself is not enough, because Parliament has done already 10 basic laws before it and nothing happened, because the court did not view it as a constituent activity. So my theory about the Israeli constitutional change or revolution is that it is a combination of Parliament as a constituent assembly plus the courts as giving effect to this constitutional revolution. Without Parliament, it wouldn't happen. And I gave you the example of my case in the 90s. It didn't happen. So we waited for Parliament to do, and Parliament has done. But Parliament, in a common law system, not in a common law system, Parliament itself is not enough. The court has to say that what was done is of constitutional force. The court refused to do it in the past. We have done it in the Bank HaMizrahi case. So my view about the constitutional revolution of Israel is a complicated view. It is a combination of Parliament as a constituent assembly, or as Shamgar said, Parliament as the sovereign, but limiting the sovereignty for this respect, it doesn't matter. Parliament making the first move, which was a crucial move, but second, the court coming in and saying, look, what you have done is a constitutional move, it's not just a regular move. And both Shamgar and myself, when we wrote what we wrote, we didn't say, well, Parliament has done it, it's a good idea. No, that was not our way. We gave justification. We created a theory that explained what was going, what happened here. So I had this theory, Claude Klein, of a constituent power, an original power in 1948, which everyone agrees apropos that our first parliament was a constituent power. No one disagrees about that. But then I said, okay, and its powers, and that they tried to transfer their powers to every other parliament is also clear. That they tried to do it because they say so. The question is what they said effective? Because the theory is, after the first parliament, this constituent assembly dissolved, that's the end of the story. So we say, no, it's not the end of the story. So it continues. Which means we have a constitutional revolution. It is a revolution in the sense that it's a major change. The law before it and the constitutional law of Israel before it and the constitutional law after it is not the same constitutional law. Now, I was on the Supreme Court 28 years. It's a long time. 14 years before the constitutional revolution, 14 years was after the constitutional revolution. And in my second 14 years, I had to destroy what I've written in my first 14 years, which was not an easy thing for me to do. But I thought that's the right thing to do. So it is a revolution in the sense that it is a change, a major change. And it is a constitutional revolution because it's a change on the constitutional level. And it is a constitutional revolution because it was done, at least according to what we think, in a proper rule of law, in a proper constitutional scheme, fitting the legal understanding or the legal culture of our society. We didn't say, I like this basic law, I think it's a good idea that it will have a constitution, we have a constitution. This was not the argument. I wrote, I think, 150 pages or so, just to make it clear that what happens here, what Parliament has done in 1992, is a constitutional way of creating a constitutional text. So in a way, I think there is a lot of similarity between what we have done in 1995 and what your Conseil Constitutionnel has done in 1971 with this constitutional bloc. Though we tried to explain it very carefully, and your Conseil Constitutionnel wrote 10 sentences, and who knows what's written there. But both of us have tried to justify what we are doing. My job was much, much more difficult, because you had already a 58 text, which is a constitution. And what you needed is to add to it a Bill of Rights. And you had already judicial review or preview. And so you had to add to the preview also the Bill of Rights. My job was much more complicated. Didn't have a text, that the name of which is a constitution. We had 11 basic laws in which the Supreme Court until then assumed that there are regular statutes. We had to elevate it to a constitutional level. But who elevated it? Parliament elevated it in this basic law. And we had to add to it the idea of judicial review, which we didn't have. So we added to it judicial review, Marbury v. Madison kind of thinking. But what we have done is, I think, theoretically, generally, similar to what was done here in 1971. Now, the interesting thing is that our decision in the Bank HaMizrahi case, of course, was connected very much with basic law, dignity, and liberty. Then the question immediately came up, what about the other 10 basic laws? Are they also on a constitutional level? Or do they continue to be regular statutes, as the Supreme Court earlier said? And only Bank HaMizrahi, and only this basic law, because this basic law says on itself that when you construe it per se, is of a constitutional level. And then we decided in a line of cases, I apologize, I wrote them, that this revolution, this constitution applies not only to this basic law, but applies to all the basic laws. This is not a natural move. But I think it's not a natural move under the theory of Shamgar, in which Parliament is sovereign, and so Parliament can bind itself, but it has to say so. No, did they say in those basic laws? They didn't say too much. Under my theory of constituent power, it applies because all those were done by Parliament as a constituent power. They were called basic laws, and when Parliament has done it, it had this subjective understanding that it is acting on the constitutional level and not on the sub-constitutional level. It's not a regular statutory level. So we applied later this constitutional revolution. We applied it to not only to this basic law, to all the basic laws. Now, of course, is it democratic? And my answer is yes, it's totally democratic. And Dave probably will talk about this question of legitimation, etc. I don't want to go into it. But what I want to stress is the following thing. Even if we have a constitution, as Parliament has declared that we have in 1992, plus the Bank HaMizrahi case that says, yes, that's a constitution. Even if we have a constitution, it's a very, very limited constitution. It's a bad constitution. I called it a crippled constitution. For many, many reasons. One of the reasons is because you can amend it very easily. Basic law, dignity and liberty can be amended by our parliament by having a vote of 2 in favor of amending, 1 against it. We don't have quorum in our parliament, quorum requirements. So it's very easy to amend it. So is it a constitution, if it's so easily amendable? Well, it depends on how you define the concept of constitution. If the constitution means a text that is difficult to amend, we don't have a constitution. And the whole thing is not a constitutional revolution. It's just a change. But if you define constitution, and that's my definition, to include the idea that it is above the regular statute, it's above the day-to-day politics. And if a regular statute limits or violates this text, which we call a constitution, then this statute is unconstitutional. And any court in the country, not just the Supreme Court, any court in the country, this is what we decided, any court in the country can declare this statute as unconstitutional. Of course, it will work between the parties and not erga omnes. When it comes to the Supreme Court, then it will have a larger effect. So our parliament could knock out Bank HaMizrahi case. The day after the Bank HaMizrahi case was delivered, our parliament could decide that we don't like the Bank HaMizrahi case. We can knock it out by 2-1. And let me tell you, I would declare this knocking out constitutional. As you know, I have a theory of the unconstitutional constitutional amendment. But I wrote in many places, this would not be an unconstitutional constitutional amendment. This would be a constitutional amendment. Because the idea of an unconstitutional amendment assumes that there is a constitution, that the project of the constitution is over, we have a text, and you cannot by amendment change the character of this text. But we don't have still. Our text is still partial text. The basic law line of thinking, the basic law tradition is still going on. Therefore, the idea of an unconstitutional constitutional amendment, though it applies only to us, but on a much more limited era. So I also think that our Constituent Assembly, our parliament, cannot do whatever it wants. I don't think it can change the nature of Israel as a Jewish and democratic state. This it can do. But within those very limited range, it can do whatever it wants. It has not done it. And Claude mentioned it because Rabin was assassinated 3 days later. So it didn't happen immediately. But look, since then until now, more than 20 years passed. No attempt by parliament to change Bank HaMizrahi happened. Now, I'm not saying that parliament, by not constituting, is creating a constitutional text. That's not my argument. By not doing, parliament doesn't do anything. But all those who argue that what the court has done doesn't have the democratic legitimacy, because here are a group of members of parliament in 1992, or parliament in 1992, not knowing what it's doing, more or less. And the court, 9 judges who know what they do, but they are not elected, etc., etc., have done all this, have created all this chaos, is not an accurate description of what's going on. Our parliament, as a constituent assembly, could knock out our decision. And they know that they could. They understand the idea of a basic law. They understand the difference between a sub-constitutional activity and the constitutional activity. They just enacted a year or 2 ago, I think, a regular statute that's saying that if Israel will, if some areas of Israel will be given back in a peace agreement or so, then you need a special vote, a special majority in parliament. And they have enacted it as a regular statute. So a case was brought in our court saying that this statute is unconstitutional. So they understand what's going on. They said sorry, and now they have a basic law they prepared a new basic law, which was not passed yet, I think, trying to amend the mistakes, quote unquote, that they have done, and to create now this need for a referendum, to create it on a constitutional level. And I think if they will do it, probably it will be constitutional. And I will not apply here the unconstitutional constitutional amendment idea. So what happened in Israel is a very complicated situation. Every country is complicated, of course, and what happened here in 1971 is very complicated. In a way, much more complicated than what we have done. And I cited what you have done, and I'm very critical apropos. I'm not critical what happened here, but we have also a similar situation, because our basic law also says, this basic law, dignity and liberty, says that our Declaration of Independence should be taken into account. And then the question was, does it make our Declaration of Independence as a constitutional text? Because if it does, our Declaration of Independence has the right of equality. And there was a judgment written, yes, it does so. This judge did not cite the French example because he didn't know about it. But I, knowing about it in a book I wrote on this question, said it's very problematic for me. There is a French example to it. But I myself, this is what I said. I don't think that the mentioning of the Declaration of Independence in the 1992 statute makes the Declaration of Independence of statutory force. And all the rights that it provided there are of constitutional force. Of course, I don't need it, because I have a basic law that says that all these rights are there. Maybe if I would be in the French situation, I would say exactly what the French judges have said, the Conseil constitutionnel. So every legal system has its own problems. But what we have tried to do, and I'm now talking from the point of view of a judge, is not to create an unconstitutional constitutional revolution, because I don't think judges can do it. And at least being a very faithful judge, faithful to my role as a judge, to the limitation of the power of the judiciary. I know it very well. We were looking to a theory that allows us to do it. And the beginning of this theory is Parliament itself. Without Parliament, it wouldn't be done. So this combination between Parliament in 1992, we in 1995, created this revolution, this constitutional revolution. Now, and with this I'll finish. A court that creates a constitutional revolution once a week is doomed. But a court that is faced with the possibility of recognizing a constitutional revolution when it comes one in a decade and misses it is doomed. And I think we have catched the moment. And let me tell you, I subjectively felt when I wrote the Bank HaMizrahi case that I am sitting in a historical moment. I understood very well that this is an opportunity that is coming and will not come back. Either we do it now, or it will take who knows how much. So I felt the waves of history around there. Regrettably, it's a very long judgment because we didn't have time to make it short. I wanted it very much to be, because students cannot read it. It's too long to be read. It's not as short, it shouldn't be as short as your ones here, but 30, 40 pages should be enough for that. We didn't have time to do it for reasons that it's not technical reasons. We had to give it very, very quickly. We must have give it in very, very quickly. I think I wrote my whole judgment in 2 weeks. This is the time I had to write it, and I didn't have time to shorten it. But when I was writing it, I had the feeling that that I'm a part in a chain of creating Israel as a democracy and creating Israel as a constitutional democracy. And that this opportunity should not be missed. Because if we will miss it, we are doomed. Thank you.
Thank you very much, Justice Barak. It was for us really a privilege and a rare opportunity to interview Madison or Sieyès and now Barak.
You see, my problem is the Americans are talking all the time about Madison and Jefferson and all these guys who are dead already more than 200 years. My Madison, my Jefferson are still alive and going around. So, and they were, after our Bank HaMizrahi case, our Madison and Jeffersons and Hamiltons came to us and said, no, this was not our intention. So I had to overcome this problem too. So we had to create a theory of interpretation that takes into account their intention, but doesn't take it too seriously.
Alors, juste avant de donner la parole à la salle, puis de me donner aussi la parole un petit peu, parce que j'ai aussi des choses qui me démangent, je vais la donner à Claude Klein qui voudrait rappeler les faits de l'affaire Mizrahi.
Oui, parce que cet arrêt Bank HaMizrahi, il faut quand même savoir de quoi il s'agit dans cette affaire. Donc, il y a eu une crise pour les villages collectifs, kibbutzim et moshavim en Israël, qui en fait étaient, une grande partie d'entre eux, en état de faillite. Et donc on a passé une loi qui permettait en réalité de supprimer une partie de leurs dettes. Et évidemment, ça pesait sur les banques. Et c'est pourquoi la requête ici, c'est Bank HaMizrahi, qui est l'une des grandes banques d'Israël, qui attaque la loi en disant, bien, écoutez, cette loi porte atteinte à mon droit de propriété. Donc il faut bien comprendre de quoi il s'agit dans cette affaire Bank HaMizrahi, donc qui est portée devant, en appel en fait, devant la Cour suprême. La Cour suprême analyse vraiment très très longuement cette affaire. Est-ce que vraiment on peut plaider contre la loi, sur le principe, etc., pour, après 500 pages, dire non, mais la loi, elle est très bien parce qu'elle est proportionnelle, c'est-à-dire l'atteinte qui est portée aux droits de la banque, eh bien, elle est proportionnelle aux buts qui sont visés, donc on ne dépasse pas. Donc c'est un arrêt de rejet. Mais je pensais qu'il était important que vous connaissiez les faits dans cette affaire, parce que c'est quelque chose de très, très pratique. Donc.
Which means that technically it's an obiter. It's an obiter dicta. Because technically we could write a very short judgment saying this statute limits property, but the limitation is proportional. And therefore we don't have to discuss what would be our view if we would decide that the statute limits property in a non-proportional way. Can we then knock out the statute? We could write it in such a way, but we would be doomed.
Bon, alors, Otto, Jean-Louis.
So, thank you very much, dear Madison, Jefferson, Barak, to be here with us. And I take the opportunity to link two of your preoccupations, starting with the statements you made in this wonderful paper. You said it is Parliament itself who gave you, as judges, the opportunity to knock out, and it gave you the ability of judicial review. Now, I'm triggered to ask, I have here the text of the basic law, and I just want to ask you, as you are a great specialist of the theory of interpretation, aval efo, where is judicial review. I don't see any trace of judicial review, neither in the basic law on courts, because that would be, I think, normally the place where you say what courts can do or cannot do. There's strictly absolutely nothing concerning such exuberant powers. And the basic law itself doesn't say very much about what would happen if the ordinary legislator, if he would be an ordinary legislator, but even this is not said, would do something which would go against it. So, you said your country is an interesting country. It is indeed a highly interesting country, because what you did introduce is a sort of metaphysics of being above. Normally, in all countries where you have constitutional review, there is some statement about what it means to be above. Above in itself doesn't mean anything. What it means technically is that indeed certain organs are authorized to quash provisions which might eventually be in conflict. Now, I don't think to see any trace of this here, but you will certainly explain this element, which to me remains an absolute enigma.
If I may, because I have a similar question, so maybe it will help us organize the discussion better if we group our questions. It seems to me that you made two different revolutions. One is to say, as you mentioned, that there is a constitution, that fundamental laws have constitutional value. And the second is that a constitution is superior to ordinary statutes, not only in the sense that they can be altered in a different mode, different from the mode in which normal statutes are abrogated or derogated, but also that a norm that would be contrary to the Constitution would be unconstitutional and therefore could be nullified by a court. Now, this second move is probably an even bigger revolution, because it's a non sequitur. It's not because a constitution is above a statute that necessarily there is the possibility of judicial review. There were many constitutions in the history of the world where the constitution was above statutes. For example, French history is full of those constitutions where there was no judicial review. So I think your revolution, the real revolution, was not only to say that there was a constitution in Israel, but the real revolution was to say, as Justice Marshall had said in Marbury versus Madison, that there is a possibility to exercise judicial review and to refuse to apply a non-constitutional statute. So that's the real revolution. And what is the justification for that?
Okay, so these two questions are
linked.
So first of all, I of course agree that it's not one revolution but two revolutions. Absolutely. And I think I mentioned it because it says that it's a constitution, but we don't have a text which says it's a constitution. And Marbury v. Madison didn't have this problem because he has a constitution. And secondly, it was the question of judicial review. So, and both of us, I agree that these are two components of the revolution. And now let's concentrate on the second component of the revolution. Now, the answer to this question, first of all, is a disputed question. There are people, until now in Israel, who think that there's nothing in this basic law that will justify judicial review, even if you call it a constitution. So it is, from the theoretical point of view, it's an open question. We can hear argument, and I participate in this discussion also in Israel, and I give my own answer to this. First. Secondly, in order to decide on the second revolution, you need a theory of interpretation. How to interpret the text. Because I, as a faithful judge, could not decide the second revolution without believing that the text itself says so. Now, so let's concentrate on the text. Does the text say so? That's the main question. Now, clearly, this text doesn't say so expressly. Clearly, there is no provision in the text that says, yes, there is judicial review. It doesn't say so. It doesn't say there is no judicial review like in the Netherlands. It doesn't say so, but it doesn't say that there is judicial review. But when you read the text, I think there are signs on the blackboard, 5 or 6 signs, that if you connect them together, you will have X means Y, Z. When you connect those things together, I think judicial review will follow. And I haven't done this job in the Banca Mizrahi, but my Shamgar has done it, because for him, everything comes from the wording of the statute. This was his theory, that parliament is sovereign, but parliament can limit itself and can create judicial review. So he had the problem to see that it limits itself and created judicial review. But let me start just several things. First of all, it says, this statute, all governmental authorities are bound to respect the rights under this basic law. Everyone, which means parliament, executive branch, and judicial branch. So every one of us have to respect it. And in Hebrew, there is a very strong word for that. What does it mean? Doesn't it? Is there an interpretive possibility to say that if Parliament enacts a statute in violation of the provision, Parliament does not respect? I have to respect it too. By not knocking it out, I don't respect it. Maybe not. Now there is another provision, and I mentioned it to you yesterday. It says, this basic law shall not affect the validity of any law in force prior to this commencement of this basic law. A special provision saying the validity of previous law is not affected. What does it mean? It does mean that old law, let's call it old law, is of a constitutional value? No. It's not. It doesn't make the old law part of the Constitution. It also said that this old law is valid, even if it violates. Now, vis-a-vis whom does this law say that it is valid? Does it mean the Parliament cannot change it because it's valid? No, clearly Parliament, if the Parliament doesn't like the old law, Parliament can change the old law, right? So against whom is this provision? Does this provision work? If you want to make sense of this provision, there's only one way to make sense of this provision. You judges cannot knock out old law. You judges cannot declare old law as invalid because it's in violation of this Constitution. Because otherwise, why do you need it?
Well, it's
as an expression
very easily. It is,
yes,
exactly. It's simply a restriction of the lex posterior rule.
Yes, you can say it. I agree. You can say it. It is an answer. What I want to say, of every one of these little 5 points I could make, I agree that none of them is critical, that none of them solves the problem. I agree. On every one of them, there is another answer. This is lex posterior, and this is lex generalis, and this is but I agree. But what I want, and I go towards you, what I only want you to go towards me with the same open-minded. And if there are these little 5, there are additional points. There are additional points here. Everyone can be 50% here, 50% well. Let's put it this way. But if you connect all those points together, you can create a graph. You can't create a mathematical kind of formula. That the real connection, that the best taken working, the best interpretation of this text taken together, is that there is judicial review. Every point by itself is not enough. I agree. But taking all this together is enough. And let me add, Parliament understood it very well. They understood it. Because we knocked out statutes. And they haven't said anything. But again, by not saying anything, for me it has no legal effect in terms of the interpretation. I agree. I also agree that we don't have a supremacy clause. So my job was tougher than Marshall's job in Melbourne, because they have a supremacy clause. But he didn't base his judgment on the supremacy clause. So in addition to all these 5 points, I had a 6th point. And my 6th point was Melbourne v. Madison. Now, Melbourne v. Madison in itself is not an answer, because we know all the problems with Madison. And I agree with you, it's not enough. But if you connect all these points together, in Israel we knew very well Madison. The legislature knew very well what's going on in the United States. If you connect all these points together, one can make a point that if a court does this connection, it is not climbing on the wall. It is making a point that there is a possibility to read this statute in such a way. And that's my answer. I don't have another answer. So if you would come and say, look, none of this point is enough, per se, I agree. But I don't think you have a good answer to what I was trying to do, to connect all these points to a comprehensive theory of interpretation, the result of which is judicial review. Don't also forget another thing. We had already judicial review before, the Bergman case. The Bergman case doesn't explain anything, and this per se clearly is not enough. But it's a little point on the blackboard, Bergman. And we had, after Bergman, we had a line of cases, because I myself was sitting on these kind of cases, that we exercise judicial review on this specific situation, legal situation. It's different. But the culture of judicial review was already built in our system in a limited way. So taking all this together in a theory of interpretation which does not rest only on intent of the legislature, though there may be such an intent too, I can find it. But my purpose of theory of interpretation, to the holistic way of thinking about it, I think I have a 51%. Which is enough.
Wonderful. Jean-Louis, maintenant.
Thank you. After your fascinating speech, it's difficult to ask a question about vocabulary, but we will be doomed if we don't take the opportunity to ask you questions. At the beginning of your speech, you have identified the rule of recognition and the legal culture. You have said our legal culture is our rule of recognition. Then you have said that the rule of recognition, the beginning of the rule of recognition is inside the text, decided by the Parliament, and then in the interpretation by the court. Do you mean that the legal culture is the recognition of the rule of recognition? And is it sufficient that judges of the Supreme Court has recognized the rule of recognition to make a legal culture, or is it necessary to have a more general consensus among lawyers and perhaps among the whole population?
Well, of course, this question, of course, comes up. In my judgment, inter alia, I relied on 3 sources. In addition to what I answered now, I make a reference to Kelsen, to H.L.A. Hart, and to Dworkin. Kelsen I have not met, but Hart and Dworkin were friends of mine, so I knew very well their views and etc. And I tried to explain inter alia, to make a point that what I'm saying fits every one of them. So, for example, the rule of recognition. Yes, there is a rule of recognition. For Hart, the rule of recognition is a judicial rule. Now you ask me, yes, but do you have a rule of recognition without a culture? My answer is no. I myself think no. But there was the culture was there. The culture was there. Bergman is part of the culture. All the judgments that were given there is part of the culture. Mary v. Madison is part of the culture. All these are, for me, part of the culture. Not enough, I agree. My judgment in the early 90s, why have I written this judgment? It was an obiter, clearly an obiter by a minority judge. I was in minority during the judge. I've written it because I wanted to create an understanding to the problem in Israel. Therefore, I said the culture now is that we go according to the basic laws. For the time being, I said, for the time being, it can be changed. So this is also part of it. So if you ask me theoretically, I as a theoretician, do I think that you may have a rule of recognition out of the blue sky? The answer is not. I don't think so. And I didn't just cite H.L.A. Hart. I also cited Dworkin because I really think that the best interpretation of our legal history is what I wrote. And so I needed his best interpretation theory to reach my agreement. And also Kelsen.
Alors il y a encore 2 personnes et 2 minutes. Donc monsieur et puis Arnaud Le Puer.
Thank you for your presence. 2 small questions. The first question is, you spoke about major change instead of constitutional revolution. So what kind of change it is? Is it a change in the law, a popular change in the population, or political change? My second question is, you said the parliament, the Knesset, made the revolution. This is not the judge. But we know, with Montesquieu, that the judge is the mouth of the law. So don't you think that the mouth, the speaking of the judge, what the judge says that the law is the more important? So these are my 2 questions. Thank you.
So as far as what is the change, I was not talking about political change. I'm not a politician. Just to answer a question that Claude was asked. You know, in Israel, our system of appointment is such, no one in Israel knows what my politics are. No one. No one in Israel can say Barak was appointed by President A, a Republican, and the other guy was appointed by President B, and he was appointed by your president, and he was appointed by the Senate, etc., etc. So they have political classification. No one can classify any judge in Israel about his politics. So it's really an on-the-merit appointment. Of course, all these appointments were created, the system was created before the Constitutional Revolution. With the Constitutional Revolution, now the politicians want, of course, to change the system, to have their own people. And I, as Chief Justice, my main role, I was 11 years Chief Justice. 11 years my white hair comes from my fight with the politicians, not to change the system of appointing judges. They also wanted to appoint a special court, a constitutional court, a Conseil Constitutionnel kind of, and I refused. And I was very much against it, and until now successful. So it was not a political change, not politics, etc. The change is in the, as I tried to explain, is in the structure of norms. Before Bank HaMizrahi plus this basic law, the highest norm in the land was stated by our parliament. There was no legal norm above it. Now there is a legal norm above a regular statute, which is the basic law. Basic laws is above it. And this immediately creates the judicial review problem and the protection of rights problem. So that's my answer. What is the... Now, as far as the mouth of that the judge is the mouth of the legislature, I don't believe in it. And how many do believe in it today? So we should tell the truth. We should tell the truth. The judge is not the mouth of the legislature. But also the legislature is not the mouth of the judge.
But he has to say it too, so that the people can involve it before the court. People can say,
That's
this
right.
is my right. So.
That's right, yes. And yes, we do, we say it. I myself have written many. I've written 15 books just to say exactly those points. Yes, I've said it. We are a constitutional democracy, which means that we have 3 branches. They are brothers, co-equals. One is not the mouth of the other. And therefore, this co-brotherhood, so to speak, this is what is so, I think, nicely exemplified in the Israeli legal system. Only if we cooperate together, and therefore we develop this idea of a dialogue. Only if we have a dialogue between these 3 branches, our democracy will be saved. Because the strong brother is not the judges. You know, Stalin once asked the Pope, how many divisions do you have? How many divisions do we have? None. None. So we are not the strong one. And I always say, there is a partnership between us. You are the brother, the older brother, we are the young guys. Fine, fine. But please note, we are brothers. And it's not that that I'm a son or a grandson, etc. We are brothers. We are co-branches in the state of Israel. And when I'm writing a judgment, I'm not doing something which I like to do or don't like to do. I have the responsibility of a constitutional judge. It's a major responsibility. But what we have done is not just this revolution that we talk here. I think we have done other things. Non-justiciability question, Claude mentioned it. All those questions from the West Bank are loaded with politics. We take them, we adjudicate them. We don't say it's a political question doctrine, no, like the Americans. Standing, which is a question you have here. We have given standing to everyone in Israel on those matters. Everyone. An NGO has standing, you have standing. So we have done other things also to open the channels and to allow a court to say what the law is. But it's a limited function. It's an important function. It's a limited function. And it's not the mouth of the legislature.
Alors, je me tourne vers les organisateurs. Est-ce qu'on peut prendre encore une question et abréger la pause un peu?
Oh, je pense, oui.
Oui.
Je pense.
Alors, donc, Arnaud.
Thank you. One of your arguments was to say that after all, the Knesset, the parliament could have, after the Misrael case, could have turned it down, and that it didn't, right? So just to be sure, if I understood well, the Misrael case was it was a prospective overruling. It didn't declare void the statute. So do you mean that that the parliament could have adopted a statute that would forbid the Supreme Court to exercise judicial review? That's what you mean? Yes?
That's the question.
I have another question. If you answer yes
okay,
or
so
no,
let me answer the first one.
depending on what you
Yeah. Parliament could knock out, change our decision, but in order to do it, it could not do it by a regular statute. It had to do it, under my theory, only by a basic law. By an amendment to the basic law, let's say dignity, or amendment of the basic law judiciary, which is really the right place here, right? To put it, no judicial review. And if they would do it, then it will be it will be effective as from the day on. And if there would be in between in the middle judgments that knocked out statute, that will create a problem. Now, it's not a prospective overruling. What we have done is not a prospective overruling. We have not overruled anything, because it's an obiter.
Yeah, okay.
It's just a big obiter. But then, in no time, new judgment came in which it was not an obiter. It was the ratio of the case. and they have made the same decision.
So you wouldn't have considered, that's my further question, you wouldn't have considered the suppression of judicial review in general by the Parliament as an unconstitutional constitutional amendment?
Well,
Because that's
yeah.
what courts usually think.
Well, so I mentioned it in my answer. I wrote an article on the unconstitutional
Yeah.
constitution and participated with Otto in a conference on that. So I think that the unconstitutional constitutional amendment is a valid positive theory. That I do think that an amendment to an existing constitution, an amendment to the constitution, cannot change the basic structure of the constitution. If you want to change the basic structure of the constitution, you need a new constitution. Carl Schmitt kind of idea. You need a new constitution and not an amendment to the old one. That's my theory. I know all the problems with it. And this theory of mine is based on the interpretation of the existing constitution. See, this is another interpretive move. But what I was saying is, in Israel we don't have yet a full constitution. So what is to change the basic structure of something which is not yet there? Therefore, it can apply only in a very limited way. And the limited way is the following. I think all the constitutional power of our Constituent Assembly comes from our Declaration of Independence in a way. So the question is, are there limits on the Constituent Assembly? That's the question. And I think that there are limits on the powers of the Constituent Assembly. And that's the powers, not the limitation, if I can draft it, I can summarize it, is not to create a constitution which will violate the basic idea why there is a state of Israel, why there is Declaration of Independence, and why, etc. So if what they would be doing is create a dictatorship, for example, they couldn't do it. Neither by Constituent Assembly, but neither by an amendment, and I'm even not sure they can do it by a new constitution, because I think it's even a limitation on a new constitution. But we are moving now to.
Yeah, but if I just add just a little thing, if you suppress judicial review, you can't guarantee what you say. So you need judicial review to limit the constituent power, the amending power. So that's why I said usually courts say that the judicial power, the judicial review is part of the basic structure, because otherwise you can't limit amendments.
No, my view is, and I have authority for that view, because also in America, for example, Holmes said that the American Constitution can very much continue its life without judicial review at all, and limit judicial review only to federal questions. But as far as the Bill of Rights, we don't need judicial review, and I think he's right. In the Netherlands, they don't have judicial review regular type, and it's fine. So I don't think judicial review is a necessity for to knock out judicial review would be an unconstitutional constitutional amendment. I don't think so. But after we will have already a full constitution, the process is over, and we will have their judicial review, then maybe I would think that if then you will knock out judicial review, this may be an unconstitutional. Because otherwise you create a situation in which Parliament, as a Constituent Assembly, the moment they enact a statute, they bound their hands all the time, more bound and bound, because a new statute, they cannot amend what they have there previously. No, that's not the way. That's not the way that I think an objective judge should look about the process. Until it's finished, it's not finished. And they can have the power to move, to rechange. Suppose they will say, look, you know what? We will have a full Bill of Rights. In Israel, we don't have a full Bill of Rights. We have a very limited Bill of Rights. We will have a full Bill of Rights, etc., but without judicial review. As a national compromise in the country. I think that they should have this power to make this compromise. I would hate the compromise, but I think they should have the power to do it. But after the compromise is done, after they sit in Philadelphia, after there is a text, and now they start to take out of it basic structures, that they can't do it. So it's complicated too, as you say. I have very complicated views.
Asher Koyach.
בשעתו היה.